Tom Manzo, and I'm president of the California Business and Industrial Alliance. We're a trade association dedicated to bringing awareness to a crisis that affects every employer and freelancer in California. It's a crisis we call PAGA. Welcome to the California Labor Law Odyssey, and we are shooting this first show from our new international headquarters in sunny Sunland, California. And I'd like to introduce Robert Pepple, attorney from Nixon Peabody. Rob, thanks for coming to the show.
Good to see you, Tom. It's been, what, 3 or 4 years now, give or take?
Give or take. And we've known each other. You were part of PAGA when it started back in 2017. Appreciate all your support and sticking with us through all these years.
It's been a great ride, even if the law gets more and more difficult to navigate.
Speaking of getting more and more difficult, it's good to get you on the show and get a perspective of what the attorneys are seeing out there. You know, how do you think PAGA cases are accelerating? Are you seeing more of them than you did, when we first met?
Yeah, well, everyone's been waiting for, and it has come down, a case called Adolph v. Uber. And there is an important standing issue, which I'll try to kind of break apart a little bit. Back in the summer, the U.S. Supreme Court had decided a case called Viking River, which had held that arbitration agreements, which would have class action waivers, which is an agreement that says that you agree to proceed with your case individually in arbitration, that those were good, those were upheld. And so everyone was very excited. We had a lot of cases about that where individuals were being pushed into individual arbitrations, which is great because once that's done, the case is over. And as you know, Tom, a lot of these cases, they end up with an employee who really probably has no claims or has very weak claims. And it's really the threat of that larger litigation that forces employers to settle, and oftentimes it's cost prohibitive to proceed to trial. But what happened with the California Supreme Court is they took a specific line in Viking River by Justice Sotomayor saying state courts may have the last word on standing, and they took that and they ran with it. And by that I mean the California Supreme Court has decided that the standing issue, when you are in individual arbitration, doesn't necessarily mean you don't have standing to pursue all those claims in the Superior Court, which is like having two parallel class actions going on at the same time, although the courts are still a little unsure about what the order of operations is, whether or not you proceed with the arbitration first and you come back out. And there are even some cases out there that are saying that even if you win the arbitration, it may not kill the case.
You know, what's kind of interesting is we were the only group in the state of California when the Uber case was decided in the employer's favor by the U.S. Supreme Court. And we offered no-charge arbitration agreements. And at that time, there was pushback where, hey, maybe it's more expensive to arbitrate a claim. Maybe arbitration isn't the way to go. And it still seems there's a lot of confusion amongst employers. Rather, should they have an arbitration agreement or should they not have an arbitration agreement? And if arbitration does not help in a PAGA case, then why should I have an arbitration agreement? And I think that's something a lot of employers don't understand. And maybe you could just give us a quick summary on why you think they should have an arbitration agreement.
Yeah, well, two-pronged answer there. Well, first of all, an arbitration agreement is a contract like anything else. If you have an arbitration agreement, you can always choose not to enforce it. That doesn't mean the other side won't choose to enforce it. However, we don't see very many plaintiffs' counsels choosing to arbitrate. Generally speaking, they want to be in court. They like the idea of that class or representative action pressure on an employer. So having an arbitration agreement doesn't mean you necessarily have to enforce it. So that's point one. The other part is we have to remember that California's got two types of collective litigations. You've got traditional class actions. These are the class actions that typically go back 3 or 4 years, right? And they have class action procedures. They're subject to the California Code of Civil Procedure, right? And then you have PAGA, which is kind of its own animal. So PAGA is the one, of course, you've been focused on. It's one that CABI has been focused on. And the difference between that is this arbitration fight has been whether or not arbitration agreements are effective as to PAGA. There's no question that they're effective as to class actions. So it is, generally speaking, an excellent idea to have an arbitration agreement with a class action waiver, because whereas it may not help you in the PAGA context as much as we hope it would, it will help you with respect to those class actions, because it is still very good law that if you have an arbitration agreement with a well-drafted class action waiver, that you can push them into individual arbitration on those claims. And what we're seeing in the courts is that plaintiffs' counsel don't even bring the class action if you have an arbitration agreement with a valid class action waiver. They pursue PAGA only.
Wow. So PAGA only is 1 year. Traditional class action would take it back another 3. So you potentially are reducing your exposure quite a bit by having an arbitration agreement.
Significantly, yeah, and especially with high turnover businesses, the more people that you hire and fire, these cases are typically settled and they're resolved, and oftentimes, damages are calculated in court on a per work week basis, right? So that period of time from 1 to 4, and to be clear, there is a special statute of limitations issue there, which I won't get into now, but essentially the SOL for many claims is 3. There's a UCL claim. I guess I am going to get into it now. And then there's an additional UCL claim, which brings back 4 years, but that's kind of getting too much into the weeds. But yes, it does reduce your exposure and your timeline significantly.
Right. Now, this year alone, how many PAGA cases have you been involved with?
Involved with? Oh, probably 20 or 30.
20 or 30.
Yeah, we probably mediated a dozen or so. The pace is definitely picking up. And because the law is sadly settling, right, we continue to get really, really difficult decisions from the California Supreme Court that seem to be adding pressure onto employers, right? Very rarely do we get a ruling that helps employers in any significant way. I think the last one we had was called NAZAV Superior Court, which held that PAGA penalties cannot be individualized. But other than that, these rulings that keep coming out, and that's in line with the California public policy of being employee friendly, but it is narrowing the playing field for arguments and for marriage arguments that we can make.
Okay. So on the mediation, I think a lot of times people just don't have that clear understanding of what is mediation, what is it like, what am I going to expect?
Yeah, it's a good question. So essentially speaking, when you have a lawsuit, it can be resolved in one of several ways. One is a trial court proceeding, right? Sometimes a jury, sometimes just a judge, right? That's what employers want to avoid, because the cost of litigating claims through trial is extremely, extremely expensive. Then you have arbitration, which we were just talking about. That is similar to a court proceeding, in that you have a third party, right, an arbitrator, in lieu of a judge or a jury, that is basically saying, I'm going to look at the facts, I'm going to look at the law, and I'm going to tell you what the result is. And there's almost no way to get out of it, right? Appealing to arbitration decisions is very difficult. Mediation is neither of those things. What it is, it's two parties coming to a table with an experienced neutral, right, that both parties pay a portion of. And then that neutral goes back and forth to try to seek a compromise that nobody really likes. And the idea between mediation is that with these cases where you have significant liability, right, and you have these cases that are all over the place, oftentimes it makes sense to go to mediation, if only to see how the other side is viewing the case and to see what you could resolve it for long before trial. And what I can tell you is that with the landscape of California law, especially the employee-friendly statutes, you're seeing plaintiffs' attorneys who are willing to resolve cases at significant premiums because they have so much work, right? So they're going to fight the big ones, they're going to fight the one with the really bad facts, but if you have relatively good facts, then it may make sense to go to mediation and just get it over with, because the cost of defending that case may eventually end up being more than the actual liability that you're defending.
Wow. So are you seeing in mediation cases being settled higher this year than last year?
Absolutely, yeah. On the heels of Viking River, which was the U.S. Supreme Court helpful decision, right? Well, actually, the cases were not settling because I think the plaintiff's attorney knew the California Supreme Court was going to kind of reach out and kind of mess with the standing portion of things. But ever since Uber came down, the things have skyrocketed because the plaintiff's attorneys know that, if we don't settle mediation, it's very, very difficult to beat these cases on any we call summary proceeding. For example, summary judgment. Basically, they know they have a really clear roadmap to trial, and even if they lose, even if they only win a couple of claims, they know that's going to inflict such an incredible expense on an employer, right? Sometimes up to $1 million for a trial budget, that they can pressure employers saying, look, even if I only win a few claims, you're still in this for $1 million. You might as well just give me some money now.
Well, I've been involved in some, mediations as of late with some CABIA members and some of our clients on the HR side of things. And I have to tell you, they're nauseating. I mean, it's an all-day event. And, the other side starts with a sky-high number and continues to try to, in my opinion, extract as much as they can from the business owner. And without even having that many facts, they're just pulling this number out of the sky and saying, this is what we think you owe based on amount of pay periods. Is that what you're saying as well?
Well, like anything else, the quality of lawyering differs across different firms. There are some firms out there that do a very good job, right? And then you have some firms that are out there probably just for a little bit of money. What we do see is that the math in these cases can support those incredibly high estimates, right? One of the grievous problems with PAGA is that it does not require someone to prove individualized damages. As you know, it is assessed on a per pay period basis.
Right.
So if you just take a number of employees and multiply it by a number of pay periods by 15, 16, 17 different claims, that number can skyrocket,
Right.
right? And so it's rather simple for someone to walk in and say, this could very well be the picture of the world. And even if it's not, right, I know maybe some part of this picture of the world is accurate. And that's kind of really where that middle ground is oftentimes these plaintiffs' counsel come in either having not worked up the case or because they don't have the information to work up the case. Sometimes employers don't hand over the information that they need to assess these things. But yeah, what you do see a lot of times is plaintiffs' counsel come in and they negotiate for as much as they possibly can get. And that's by maxing out the math on the cases.
Right. Right. Which is really unfortunate. Now, do you see any kind of trends for next year? Are there any new laws that have been passed where you feel potentially it's going to be worse for employers in 2024?
So we're definitely still waiting for the courts to resolve the ultimate Adolph v. Uber issue is what happens if you take a PAGA plaintiff to arbitration and you win? Because right now the law is unclear about whether or not that ends the case, right? And we've actually had some bad decisions on that. So that's one thing, is figuring out.
And when you say bad decisions, I mean, not to interrupt, but is it bad decisions from the California Supreme Court? Is it the Superior Court? Is it the Appellate Court? Where are a lot of these misleading, decisions? Because people just they're not sure. It seems even in the attorney world, a lot of times people are not sure because it's been ruled one way or the other.
Right, and I would clarify when I say bad, I am not impugning our judiciary. What I'm saying is they're bad for the employer.
Okay.
And so these decisions are coming from the courts of appeal. The way it works, just a quick thing on California jurisprudence, is that the California Supreme Court, its decisions bind all California courts.
Okay.
The California courts of appeal, those bind all trial courts. Trial courts' decisions don't bind anything, right? They're just their own decisions. So when I say we have a bad decision, the California courts of appeal are interpreting Uber in ways that are unhelpful to employers.
Got it.
Does that help?
Yeah. Oh, yeah.
Yeah.
I think, a lot of times, business owners, a lot of our members, we are more focused on growing the business.
Mm-hmm.
We want to build the business, expand the business, and do the best we can for our community. And, do that by employing, the community. And I think a lot of times we just don't understand a lot of this because we haven't taken time to understand it. But then all of a sudden you get a crash course on it when you get a PAGA notice.
Yeah, no, that's one thing that we've been seeing a lot in my cases is you do have these very well-meaning employers. I have been fortunate in my tenure as an attorney to never really have a client come to me who's been doing the wrong thing on purpose, right? I have found employers who are doing their level best to try to do what's right, but it's taking me 10 years to figure out what's going on, right? And these claims, they differ every day. There's a ton of nuance inside of them. And to answer your other question about cases that we're watching, is that there is one more case out there that is a bit technical, but incredibly important. And the case is, I believe it's Strata, and there is a procedure in California litigation, or actually all litigation, called manageability. And I call it class action light. And what manageability is, says a trial court has inherent authority to say, you know what, I have to make sure this trial can be done in a manageable fashion, right? I can't have thousands of witnesses coming into my courtroom. I've got other stuff I have to handle. The current case before the California Supreme Court is whether or not courts still have that discretion with respect to PAGA alone, which is super interesting and very terrifying. Because in no other statute anywhere in the world does a court get removed of its discretion to run its trial docket calendar. However, we've seen some incredibly difficult decisions on PAGA where decisions have come down that really none of us can really understand or make heads or tails of. So whereas normally I would say with any other statute, I would not expect it to go the way of the employee, but with PAGA, all bets are off.
Wow. Well, that doesn't sound good. So, to kind of wrap things up a little bit, again, I appreciate you coming out. Do you have one or two pieces of advice, tips that you could give our listeners or viewers on what you think they could do?
So start with the low-hanging fruit, right? Optical compliance. Look at your pay stubs. Right, I can't prove it, but I know oftentimes what happens is that a plaintiff gets fired, right, and they're fired and they're mad about something. I was fired, I shouldn't have been, this or that. I cannot imagine that any employee in the world has ever walked into a plaintiff's counsel's office and said, my pay stub is wrong.
Right.
That doesn't happen. So, and I'm sure we see all these PAGA lawsuits, so I'm not sure what's happening between the time these people walk in the door and they walk out with a retainer agreement for a PAGA case. But starting with your pay stubs and making sure those are bulletproof is going to be your best defense. Because in these types of cases, if the documents are wrong, it's hard to win, right? The other stuff like meal breaks, rest breaks, which are based on evidence and testimony, you at least have a fighting chance. But if your records are bad, then you're going to have a bad day. So my advice would be is get a hold of someone that can look at your records, the pay stubs you're printing out, your time records, make sure that they're accurate and to the we call paying to the punch, making sure you're paying people for all the time they work. Other stuff like that, that when you generate paper in the employment of another human being, that paper is solid and abides by best practices, not just the law, but best practices. That's going to be your best defense to what we call a drive-by lawsuit. Otherwise, you want to make the people work for it. So that would be my best advice.
Well, that's some really good advice. Rob, I really appreciate coming on the show and being in our inaugural episode here. And, we thank you, very much for all the good work you've done, not only for our organization, but some of our members, as well as your own clients, because it is difficult to, find very talented legal expertise when it comes to these types of cases. One thing I will say to all our listeners and viewers today, anybody that wants to send Kavya your paycheck stub and let's review it, send it over, we'll take a look at it. We could do a deeper dive analysis if anybody feels that's necessary. But go ahead and start with that. And I want to thank everybody for watching our show today.
Well,